Welcome back to the Seeing Red podcast. I'm your host, Garrett Fultz. We have a great episode in store for you today. So, Attorney General Paxton and whatever else is being sued, but it's more in line with what's typically going on for his role because he represents the state of Texas. The state of Texas passed a bill back in the 89th session, HB 18 or 19, HB 18, called the Scope Act, which we'll get into a little bit later. But the attorneys who were suing, one of the attorneys from the organization called FIRE out of Philadelphia, which is the Foundation for Individual Rights and Expressions, I think. I'll get corrected if I'm wrong, is here today to talk to us. We have David Rubin with us here today. David is a staff attorney at the Foundation for Individual Rights and Expression. He joined FIRE after working the stand-up comedy industry, attending law school at the University of Virginia, and litigating for several years at a leading international law firm. So I just want to welcome to the show, David Rubin.
Thanks for having me, Garrett.
Absolutely. So briefly kind of talk a little bit about just who FIRE is and kind of what type of practice that it entails.
Yeah, so FIRE, you got it right. It's the Foundation for Individual Rights and Expression. We're a nonprofit organization based in Philadelphia with an office in DC where I work. And we exist to fight for and protect the right to free speech and the First Amendment, and also to promote, the concept of free expression. And we started in 1999 on college campuses, representing students who were, whose speech was being limited by, overzealous administrators. And then last year we expanded. And so now our aim is to protect speech all across the country. And so, we do that with like public advocacy. And then another way that we do that is through litigation. And that's the part that I play. I'm a staff attorney in our litigation department.
Fantastic. Well, thank you so much for taking time out of what I'm sure is a jam-packed schedule. I have never met a practicing attorney that was not just crazy busy all of the time. So thank you so much for sitting down with us. So the news stories started to break last week or a couple weeks ago that FIRE had sought an injunctive relief in pursuit of trying to nullify or overturn a certain legislation. That's the SCOPE Act, the Securing Children Online Through Parental Empowerment, which is a bill passed overwhelmingly in the Texas House. It looks like the final vote in the House itself was 120 to 21, 124 to 21 against, which, the makeup of the Texas House, pretty bipartisan in its support. Had 90 co-authors and authors, and it was, I think, led by Representative Slauson, who, if memory serves, is a UT law grad, I think class of 03. There's a lot of people from the UT class of 03 that are pretty relevant in Texas politics today. So basically what this bill does, well, actually, David, would you want to explain a little bit about what the law is that y'all are, and what the portion that y'all are specifically going after today with this action?
Yeah. So basically there's two big parts, like two big buckets of restrictions that the SCOPE Act has. The first one is on any material that is basically obscene to minors. So this would be like, generally you're talking about like sexual content. And so every user on a social media website, but really it applies to almost any website you can think of, because it applies to any website where you would create an account and then share any type of content. So any like messaging apps, or even like your banking app might be brought into this. But so every user has to register their age. And then for any site that has up to 1/3 or 1/3 or more material that is essentially obscene to minors, but totally constitutionally protected for adults, you have to go through this onerous age verification process where you're basically going to have to show your government ID to either the website or to a third party. Probably no choice over whether or not they store that data, or you're going to have to go through biometrics, something like that. And so that's a big barrier on adult access to protected speech. But what's interesting about the Scope Act is that it's, we kind of refer to it as a Frankenstein's monster of different portions of all of these kind of protecting children online laws that are being passed around the country. Because you've got that part, which is more common, the age verification, but then you have another part that says it enforces a duty, like it places a duty on the platforms to hide certain types of harmful content from minor users. And the list of that content is like, it's anything that, quote, promotes, glorifies, or facilitates suicide, self-harm, or eating disorders, substance abuse, stalking, bullying, or harassment, grooming, trafficking, child pornography, or other sexual exploitation or abuse. And it places all these requirements on the platforms that they have to keep track of, like, any kind of this material that's out there, and make sure that minors aren't being shown it. And any violation of that is like a violation of Texas's consumer protection law.
So it's not just using the obscenity statute as is for minors, it's adding to it.
Yeah,
so it's effectively adding without adding to the specific thing. So at this point, if a business, they had the back curtain for whatever, for nudity at the old video stores, right? So if that business had a movie out front that, I guess, glorified self-harm because, I don't know, there was a documentary about Tibetan monks killing themselves, then the Tibetan monk stuff would have to go, in this analogy, would have to go back next to the porn, basically.
Well, I'm not sure that it would go that far. And that's a perfect example of what is wrong with the bill, is that something that would be important for kids to view would be brought up in those definitions. But I think it would be something like, you've got the video store, and then on the side, and then anything in the store that is, glorifying eating disorders, or, could potentially, basically anything that touches on any of these topics, you'd have to have some type of tracker on it or something. And anytime a minor walks by, you'd have to have some big, huge, data set tracking whether they're viewing it or not. And then you have to come up with all these tools to prevent them viewing it. And you're probably just going to end up it's just easier to take all that stuff and put it in a different section. So you'll probably put it, I mean, I guess you would do it. You would put it next to the room with the curtain on it.
Yeah.
And then as they go past, I'm not sure if the ID check is before or after the curtain room, but it's but yeah. You're adding separate rooms. Yes.
Right. So it's adding more stuff, but it's only to online stuff, because those things, I mean, things that were like books or whatever would still be able to be accessed in the library or anything like that. And you said it's only, is it only social media and like things with a message board, like a social component? So just normal websites that have information would still be accessible?
Yeah, well, it's actually, it applies to anything that it defines as a digital service provider, which is, and a digital service is basically the website, and it is any website, application, program, or software that collects or processes personal identifying information with internet connectivity. So I was too charitable before. It isn't even anything where you have to have an account. It's any website that has cookies, basically that process your information, that is covered by the Scope Act.
I gotcha. So I guess there's no real age identification without identity verification. You can't verify someone's age unless you know who that person is, unless there's something I'm missing.
Well, that is another complicated part of it, that there are two levels of age verification. Well, there's what they call age registration, which is
Mhm.
that basically, in order to access the website, you have to click. I assume it's going to be a window that's like, you're either 18, are you 18 or not, or what is your birth date? So
Mhm.
you already have to give that information before viewing any content.
Mhm.
And then um, anyone who's registered as a minor, that's when all these requirements to like track their access to this harmful material, like
Mhm.
about, suicide or whatever. That's when that's when all that tracking requirement comes in. If you do or are afraid you have 1/3 or more content that is obscene for minors, so essentially like anything of a sexual nature, then you have to do age verification, meaning you need to collect the biometrics or the government ID or what have you.
So if you have user submitted data at all, basically, where a bot can come in and just spam post and no one's seeing it, but it still constitute part of the data, you may fear that you're going to hit that 1/3 mark and then be under the eye. Or what are the consequences of not doing it?
Well, because it places the requirement on you, and a failure to do so is a violation of the consumer protection laws, then it would. I don't remember offhand exactly what the amount of the fine is, but I know that there is. It's going to be something like every infraction is punished as a specific violation of consumer protection law,
Jeez.
and those could add up,
Yeah,
in
in
the
a hurry.
millions.
So it's a consumer protection enforcement. It's not a civil. It's like not like a parent can sue on behalf of because their kid did something. It's just going to be only the state can sue.
Yeah, it's specifically the enforcement subchapter says this is you know this is a deceptive trade practice law, and it specifically um, oh well, so it says that the law can't be construed as providing a basis for a private right of action, um,
Okay.
but it does allow for a parent to bring an action seeking a declaratory judgment or an injunction.
I
So,
gotcha.
but no damages.
Okay. So there's not really a private attorney general aspect to this. It's just a state action, I guess, is what I'm trying to get to.
Correct.
Kind
Yeah.
of to kind of bring it back a little bit. I've noticed, and I'm not sure if this has persisted through time since the First Amendment has existed, or if it's something that's more new. But there does not seem to be a true, just general respect for the freedom of speech uh, that you would think people might talk about it, especially when it's speech that they like or they can control which speech is censored. Um, but there seems just to be a general kind of culturally speaking, a withdrawal from just a free speech as a value or as a value of a democratic society. And I mean, you see the fights here in even in Texas or in the United States. You see far more restrictions of just outright criminal speech in Europe and other places where you'd think that wouldn't be the case. I preface it that way to kind of say, do you like have a primer or a primer on um, just the First Amendment uh, history, like how we got to this point? Because I know there have been times in the past where they famously, and it's both famously not active, but famously couldn't yell fire in a crowded building. or in a theater, couldn't quite fire in a theater or something like along those lines. But additional tests have come along since then, and before that, I think in the Civil War, you couldn't criticize Abe Lincoln, or you'd go to jail without habeas corpus. So do you have like kind of an idea of like where we went and how we got to where we are today?
Yeah, I mean, I'm not a professor, I'm not a scholar, but I will
Sure.
give it my best shot. And I think a good starting place is, I mean, so there's more scholarship now on the founding fathers' view of the First Amendment, but it didn't really become a huge part of the legal, of like Supreme Court jurisprudence until the early 1900s. And that case you're talking about, the fire in the crowded theater, that was Justice Oliver Wendell Holmes upholding a ban, like a criminal conviction on someone who was protesting World War I.
People who were trying to tell people to burn up their draft cards.
Right. Yeah, exactly. And so
a socialist, actually.
Yeah, I think it was Schenck, right? And so, but then just like a year later, in a case called Abrams, Justice Holmes saw the light and wrote what is called the Great Dissent, and he comes out with like the most forceful defense of what we currently view as like free speech principles that you've seen in any Supreme Court opinion. And so that's kind of what kicked it off. The cases that we think of as like the most front of mind, a lot of them happened like in the 50s or 60s. Like Brandenburg is what kind of replaced the Schenck standard, which is like you basically can't you can't incite someone directly to violence,
right.
but that's like fighting words if it's excuse me. So
I think there were some things that are so just inherently offensive that if you were to say them, somebody would have to punch you in the face.
Yeah, which is funny because I think in that case it was like the guy called a cop. He didn't even call him a pig. I think he said, like this cop is a scoundrel or something, and that was seen as so bad that a cop would not be able to restrain himself. So it is right. Yeah, it depends on where you are, I guess. But then there's a lot of like campus cases, like Tinker is a famous one, where you had a student at a high school who they were wearing like armbands to protest the Vietnam War, and they were like suspended, and then the rule that came out of that is basically students on campus have free speech rights, and they can't be infringed unless they're like causing such a disturbance to the school environment that it's infringing on other kids' rights to learn, basically.
Right.
And then then you've got like the obscenity cases, like the F the draft case, Cohen, where the guy was wearing the jacket that said that in the courtroom, and then so the obscenity standard ended up being worked out as something that is like it's essentially what the Texas Penal Code uses here as like obscene to minors, but it applies like writ large. And then starting in the 90s basically, or maybe the 80s, is when you have the cases that I think are the ideological forefathers of this fight, which is basically anytime you have a new technology. Well, actually, let me take that back. It goes back farther. But the idea is that anytime you have a new technology, parents are afraid of what it's going to do to their kids. And that's generally like a speech concern. And, in our brief, we talk about like, it started out with like penny dreadfuls, and I forget what the equivalent of those in the US were called, but like dime store novels, all the way through to comic books. Yeah, exactly.
Video games.
Yeah. So then you've got video games, and then cable TV. Like there's there's a United States versus Playboy where I think it was the broadcaster was, the law basically said the broadcaster had to scramble adult content,
Yeah.
and
There was some sort of time restriction, like it couldn't be shown, like it can only be shown between like 10 p.m. and 6 a.m. basically.
Yeah, exactly. Yeah. And the idea here is, I mean, and so free speech like basically won out in almost all of those. I mean, the story of free speech case law at the Supreme Court is generally one that is protective of the First Amendment, and proving that it covers a lot of speech. And you mentioned strict scrutiny. Basically, anytime that a law is content based, like touches on, you can have viewpoint neutral, reasonable time, place, and manner restrictions, which is like, no protesting or no loud noises basically between 10 p.m. and 6 a.m. because people are trying to sleep, and
Right.
But like once you start getting into, you can't post these types of categories of content, then that's content based, and strict scrutiny is the level of review that the court's going to apply, and that means that the law has to be absolutely as narrowly tailored as possible to still achieve the government interest.
Well, isn't there an exception to that for commercial speech though? So even for content-based stuff, like the government can still restrict advertising to not, something like that. And I guess the state may argue that this would be relevant here, but I'm curious because it's not actually regulating this people making the speech; it's regulating the companies who host the speech. So it would be, it could be. The law is, like you said, it's a consumer protection thing. So why wouldn't this law fall under a lighter standard, given that it could be construed or argued that it's commercial speech?
So that's a great question, and states have tried to make that argument before. I think there's a similar law in California that the Ninth Circuit just upheld the injunction of, and I think the state of California made that argument there. The reason that it's not commercial speech is just because protected speech is posted on a platform that makes money doesn't make it commercial speech. So like advertising is commercial speech because it is designed to make money, but like a New York Times, I mean, that's not the best way to explain it, because a New York Times story is also published on a money-making enterprise, as part of a business. But no one would say that a New York Times article by a journalist is commercial speech.
Right.
And so it comes down to the nature of the speech. And really what the state is doing is, it's, you're right that there isn't a private attorney general aspect to this, but they are basically deputizing the platforms and forcing them at gunpoint to, to limit their content to certain types. And while that is a business choice, like it's a business decision what speech to allow on your platform, that doesn't change the nature of protected speech that people want to post or want to access. You know,
Okay.
does that
Yeah,
make sense?
it does. The something that confused me a little bit when I was reading through both the the bill that was as it was passed, was that it referred back to a different statute, to kind of get its definition for obscenity. And in that, it said in that definition, it referred to the whole one, which I believe I wrote down here is 42.31, which I guess is chapter 42, subsection
Yeah,
31.
Texas Penal Code. Yeah.
But one in that thing, it says it's an affirmative defense for education, science, governmental, or if the people are married. And I think there's an additional one somewhere else. I don't have it written down here. But these are affirmative defenses. Do you know if those affirmative defenses would like if would those affirmative defenses give the state enough um, leeway to make an argument that there's enough exceptions that people for the type of content that you're who you're representing may it may fall under them. I asked that because, and I haven't led the predicate on this. Is that you have four, if I recall correctly, different groups that y'all are representing? It's
Yeah, I could go through that.
Yeah, sure.
Yeah, so we're representing students engaged in advancing Texas, which is a group that represents a coalition of Texas students who are seeking to increase youth visibility and participation in policymaking.
Mm-hmm.
And then we also represent a 16-year-old high school student who uses social media to learn and read the news and connect with friends. And then we represent an Austin-based company that does advertising and marketing for nonprofits, government agencies, and local businesses. And then we also, another plaintiff is an adult who uses social media to talk frankly and humorously about his experiences with his bipolar disorder in a way to kind of humanize that. So, but yeah, to go back to what you were saying.
Right.
Excuse me.
Is there any way that those folks, since if somebody's doing something educationally, I guess there's not really an exception to the verification system that the speech they'd be looking for would suddenly become open to them if they just said they were doing it for educational purposes. The parent would still have to sign off. But I guess it really boils down to is, are adults harmed in this? Because children have limited rights. I guess if children's free speech rights could be harmed, it could be an issue as well. But the primary thing is going to be, was this law passed in such a way where it becomes too onerous on even adults to comply with the thing, or they would miss out on the speech available to them? Is that more or less
Yeah.
correct?
Yeah. I mean, yeah, I'll take your points one by one. That this law does violate Texas minors' free speech rights. Like, minors do have free speech rights, especially outside of the classroom, like especially on their own time. And to have the state say any website can't show anything having to do with substance abuse, or like a good example is our high school student plaintiff. He's done debate before, and if he has to debate like the propriety of marijuana legalization, it's going to be really difficult for him to do research or gather opinions on that topic if any website he goes to has him registered as a minor and is hiding all content that could potentially glorify substance use from him. So so that absolutely violates his free speech rights, his access to protected material.
Absolutely.
To your point about the safe harbors, the affirmative defenses in the obscenity statute is interesting. And I think, a platform, I mean, it's kind of circular, because the definition that section 43 uses for obscenity is, if I remember correctly, it like, it can't have anything. Here, I'm looking at it here. It has like no positive use to society.
Right.
It has like no artistic value.
Which is like, how does that end up being judged?
Yeah,
Like, and that's always been the argument for anything. I mean, it's once again, the classic line is like, I don't know how to define it, but I know it when I see it. Like, yeah, you probably do
Potter
know it when you see it, but how do you define it in a legal sense that this has gone from what does glorifying mean? Like, they don't, like, does it and how is that not protected speech if you're glorifying, harassment? Well, like, if you are critical of a political opponent, I mean, that could be described as harassment, depending on how the harassment is defined. So if you're glorifying that speech, like, and it's just a free speech thing, you're just talking about general stuff. Now, a conservative, or conservative isn't the right term here because I don't mean politically, like a kind of conservative attorney, like general counsel, might be telling Twitter, like, hey, you gotta put all this stuff on, these attack ads, or this political speech behind a paywall, or behind a adult wall, behind the curtain, as they should say, because who the hell knows? And guess what? 17-year-olds who need to be prepared to vote won't be able to see that information. Even if they're turning 18 before the election, they might not be able to see that to make an informed decision when they vote.
Yeah,
there are applications to this where, like, anything like that.
Yeah, you're hitting on exactly what is so problematic about it, is that there's so many vaguely, broadly defined terms that anyone can, with the best of intentions, like, we want to protect kids, like, go in there and just run roughshod. And these platforms are so big that, it's absolutely not crazy to think that they would just say, well, I mean, for our Texas users, yeah, just like, put the curtain up around anything that could potentially be, like, I'm thinking of, when I was in high school, like, it would have been nice to have social media to, like, watch someone making funny videos about, like, being bullied or being insecure or something, like, to, as kind of just like a reminder that everyone is going through it, and there's a fine line between, like, making a funny video about bullying and, like, glorifying it or something. And so, I think that throws a lot of, like, student made content into potential, into the danger zone, maybe.
Yeah, I mean, I guess for your content creator in particular, it's the classic chilling effect, right? Where
exactly
he may self-censor himself, which is the chilling effect, more broadly, which is the idea that someone may not want to get close to the line, even though they won't cross whatever that legal line is, because the line's, first off, too vague. It's not bright enough for them to make a distinction once they've created something. But also because of that vagueness, because of the consequences, they may not want to push the boundary or whatever else, and they will chill their speech. They won't say things that are protected because of that effect.
Exactly. And yeah, the chilling effect is something that comes up all the time in First Amendment law. And, sometimes you'll have laws that are passed and they're very, very rarely enforced. And then the state will come in and say, well, we're barely even enforcing this. What's the problem? But it's the fear of enforcement has everybody watching what they say. And you can't have a fully functioning society that respects the First Amendment if people feel like they have to walk on eggshells.
Absolutely. Okay, let's kind of wrap up a little bit and kind of talk about where the case is today, and kind of like what, regardless of outcome, like, what would the next steps be for how this thing gets resolved long term?
Yeah. So right now it's in front of the district court. It's a motion for preliminary injunction.
Which district is it in?
Austin, in the Western District. for Austin and Western District of Texas. And the law is scheduled to go into effect September 1st, and we're
Which will be
recording
tomorrow when this releases.
Right. Yeah. So, it's possible that a ruling comes down before then. But if it doesn't, then I think the law goes into effect. Hopefully a ruling comes soon. And then with any lawsuit, hopefully we are victorious, and then I think it wouldn't surprise me if the state appeals it, and and then we keep fighting. But yeah, then the next thing would be if it's appealed, it would go to the Fifth Circuit.
The answer may be it's not possible, but if the intent is to protect children from what's, I think what people would generally agree is harmful content, which is, why it passed 120 to 21. What would a state need to do, in your view, to be within constitutionally in line, so that it would withstand scrutiny?
So I think the important thing to remember here is that these, especially like large social media websites, have more tools at parents and minors' fingertips for like filtering content and access to specific content than anyone even really thinks about, and than we've ever thought possible. I use Twitter, and on Twitter you can mute certain topics, and if I am a parent and I want to let my kid have Twitter, to follow the news or something, but I don't want them reading about XYZ, I can put there are parental tools that I can use. And I think before using the power of the state to just make this huge one size fits all solution for every parent, every student, every family member, I think it might make sense first to try to educate citizens about how to use social media responsibly and how to use these filtering tools that already exist and you already have access to. Like the state of New Jersey did that. They recently decided that they incorporated like education on social media into their K through 12 education, and education before enforcement is usually a pretty good way to think about things.
I guess something that we haven't talked about, and I guess we'll close on this because we're kind of getting to the edge of time here, or we may be over it. But I do have one last thing: is like the statute it refers back to has like requirements for people who are married. I guess because those people are effectively emancipated and quasi emancipated. It does not have exceptions for parents who deem something to be fine. So effectively, this is the state broadening if I'm looking at this correctly, in some ways is broadening the definition of what is obscene, and it would be effectively restricting parents' rights from disagreeing with that, and making sure that the kids have the education that they think is necessary and proper. Like there's an argument to be made that like you're protecting some students whose parents wish for that to be protected, but you're not protecting others because it's just, generally speaking, society thinks that all minors should be protected from this stuff.
Yeah, it's definitely, I'm not so sure that it's expanding what is viewed as obscene for minors. Although this is one thing that I forgot to mention, and this is, I think, how it would happen, is that the law doesn't specify what is obscene for a 17-year-old versus what is obscene for a 10-year-old.
Mm-hmm.
And so if what happens is that the platform starts saying, we basically need to assume that any content that minors see needs to be fit for a 10-year-old, then you're absolutely expanding the definition of obscenity for 17-year-olds, because they're not, so that's totally right. And it absolutely is taking parenting decisions out of parents' hands, because permissive parenting is a style of parenting, and the Scope Act does not let a world exist where parents can be permissive with their students or their children on social media.
Yeah. All right. Well, David, thank you so much for coming on. We'll maybe have you come back whenever we get a little bit further along in the process to kind of talk a little bit more about it. But we really appreciate it. Is there any kind of sign off? Where can they find more information about fire or you or this case? Anything like that you want to share with the audience?
Well, yeah. And, thanks, Garrett, very much for having me. I'd love to come on again. And you can just check out our website, thefire.org. And that's
You didn't
our
start
handle.
It, right? You didn't start the fire?
We did not start it, no. And that's our handle on Twitter too. And we've got a great social media team putting out great content all the time. So I would definitely recommend a follow on Twitter.
Absolutely. Well, everyone should go follow them on Twitter. It said @thefire. And then you said @thefire.org is the website. That'll be in the description. So if you need to click on it easily or that way, please do. Thank you again for joining us, and for the audience at home and listening on podcasts or on YouTube. I'll see you next week. Bye, guys.
You've been listening to the Seeing Red podcast. It's always Texas politics and beyond. We present the facts and opinions. The Seeing Red podcast with your host, Andy Turner and Garrett Foles. Thank you, and tune in next week. And please do us a favor, hit the subscribe button so you don't miss a single episode.